was in Chico with his mother, and his previous convictions, as noted in the criminal complaint, was a conviction of lewd and lascivious act with a child in 2001, and a conviction, and that was in Butte County, and a conviction of robbery with great bodily injury, and the strike of the Butte County child molest case that then in 2002 sent him on a sentence of 20 years in the state prison. He was released from the state prison in October of 2018. As I noted to the judge, he was on parole when in September of 2020 he had a DUI arrest and later conviction for driving under the influence in the very same area, like the Upper Bidwell Park that we have here today. Those crimes are important in the sense that what they do is avail us to do what we call strikes. Both of those are felony strikes, and under California's three strikes law, if a third strike is a strike, then the person is looking at 25 years to life. Recently read an article on this case that said it would be any felony would be subject to the third strike. That is incorrect. That hasn't been correct since about 2012 with Proposition 36. So what we have with the crimes of arson is some kind of different flavors, different levels of arson. We have charged in this particular case the crime of willful and malicious arson, that is also referred to as intentional arson. That is a strike. When particularly in this view that this particular crime, it also has the allegation that there have been multiple inhabited structures that have been destroyed. As noted to the court, as of last night, there was a count of over 100 structures between Butte County and Tehama County. And what we call a necessarily lesser included crime within that crime, willful and malicious arson, is a crime called reckless arson, or unlawfully causing a fire. That is not a strike. And the importance is it is only a strike if during hopefully the cleanup of this particular fire, that we hopefully do not find anyone that has been suffered great bodily injury or death. It's only if reckless arson causes great bodily injury would it be a strike. Long way around to discuss the fact that he is currently charged with a crime that would look at, under three strikes, 25 years to life. If, as he claims, and it should be only fair to note that he claims this was an accident, that he had pulled his car off of the road and found himself in the grass, fire started, and he got frightened and left the area. He denies the statement of a witness at the area that he pushed his flaming car down into a gully 60 feet down. It is, at this point, they believe that the evidence tends stronger to the witness, who had no reason to say and describe in detail how he pushed that car off into the gully, saw the vehicle careening down into the gully and burst into flame, which then, of course, caused this monster that is called the Burke Fire. Noted to the court around noon, it was at 370,000 acres and is well on its way to the unfortunate families of this biggest fire. Well, with that, why don't we just answer questions?
District Attorney Brittany Hope here with KCRA. I know that the judge read your list of reasons as why the state or why the people were hoping for no bail. Within that was also named a search warrant or search warrants. Are you able to tell us what those search warrant or search warrants were for? And in that, do you see any evidence that he did this on purpose?
Well, that is an ongoing investigation. Search warrants are for phones. Also, a search warrant for further information in terms of clothing that he was wearing, although a search warrant wasn't necessary for that. So what we have is evidence that we continue on to say, basically, is this an accident of a man getting off into the dry grass, and his car suddenly and mysteriously rolling downhill, as he would say, or is this a situation, as the witness indicated, that had a very clear view of him from down near the creek, using physical force to push the car backwards off of where it was ice-centered on a berm next to the road and explode into what we see now.
Car got pushed backward and it was high-centered at the time he pushed it?
It was
How did he get it off high-centered just by pushing it?
Pardon?
How did he get it off high-centered just by pushing it?
The car is a rather small car, and it was already, three wheels were already on the downhill side. Not you're indicating steep, but steep enough that a car would roll down that hill.
And another follow-up question, I'm paraphrasing the judge's words here, but she said video cameras in courtrooms alter the dynamic of a courtroom for the judge, court staff, for witnesses, for the defendant himself, and that it could undermine the fairness of this trial. Do you foresee any issues with TV coverage or media coverage that media or the public should be concerned about with that transparency?
Do I? Okay, let me rephrase it for me. Okay. Do I agree with the judge's necessary ruling on that? Not necessarily. But she made her decision. She will be able to, at any point in time, open that decision. But it's not unusual for judges on that very first arraignment, when facts are not really known by the judge, or particularly the defense attorney, out of fairness to that particular defendant, to kind of clamp down on some of that media, for this imposed principle.
With the witness seeing the suspect get into the driver's seat and then get out of the passenger seat, is it believed in that time he could have possibly put the car into neutral, allowing him to more easily push the car?
Correct. And a few minutes ago, you were asking about further evidence. We had Highway Patrol, California Highway Patrol has examined that vehicle as it was there, has been secured, and it was found to be in neutral.
Did he light it on fire before he rolled it down the hill?
No, the indication is he didn't purposely light the car on fire because he was trying to get out of being stuck on that edge of that off of that berm, and being stuck on the berm. He was revving the engine. We have another witness indicating heard a lot of revving of the engine, and another witness that heard metal on rock, and the witness that indicated saw dirt and smoke, dirt coming up, and then followed immediately by smoke, then fire.
There's a lot of dry grass around too.
There's extraordinary amount of dry grass.
So maybe his attempts to get free from being high-centered started the fire?
That is the working supposition at this point.
So the people believe he didn't willfully set this fire and then push it down. They believe he was trying to get off the side of the road. It caught on fire. He watched it catch on fire, put it in neutral, put it down the ditch, and ran away.
That is our supposition. We have a witness that indicates that he watched the fire develop under his car, and then got in a position on the passenger front of the car to push the car backwards into that gully.
Any idea why he would do that?
No.
It seems like you were saying he was trying to get free, and then he pushes his car over the edge.
Well, he's trying to get free, but by pushing it down the hill, that is not a way to get it free. Let's put it that way. It is very clear he pushed that down the hill. It's going all the way down that particular hill. I point to two, because I've been asked this a number of times. Well, why would he do this? What's the reasoning? There's jury instruction that even though everyone would like to know a motive, there's not a requirement for the jury to determine what motive is.
At this time, you don't know.
The other is an old prosecutorial saying that if you try to figure out what happens in a crazy mind, it will drive you crazy.
Let's say he did call for help and he stayed there.
He did not call.
Would arson, if he did, if the roles were reversed, just that arson charge, now that we know that the people aren't really thinking that he set this, he was stuck, he pushed it down. If he were to call for help, if he were to not have pushed the car, would arson even be on the table here?
Yes, it would be still. It would be the reckless arson.
It wouldn't be the willing.
To get over there in the high grass, to be spinning his wheels and grinding the metal wheels in a highly flammable area.
So if you find somebody was injured or died in this fire, what happens to the charges against them?
If that increases the charges, it also increases the fact as to reckless arson. Remember I said that with reckless arson, that is not a strike, so he's not subject to the 3 strikes. And let me get into a little more detail there. For a reckless arson, the upper term is 4 years. With his prior strikes, you can double that. Not make him 25 to life, but you can double that. And that would become 8 years. There's also an enhancement for burning more than one building, or fire cause the burning of more than one inhabitant. So he's would look at a top of 11 years if there is no great bodily injury. If there is, and we're hoping not, but if there is great bodily injury, then that reckless arson becomes a strike, and even under his view of the facts, he'd be looking at 25 to life.
If there's a death, does it become murder or manslaughter or second degree murder?
That is yet to be found.
Those possible additional charges and enhancements can come down.
Say again.
Sorry. Additional charges and enhancements can
Correct.
come down.
The question was whether there's additional charges and enhancements.
Right.
Yes.
Yeah. Thank you.
And District Attorney, are you able to just recap today in court, he waived the right, or he waived the reading of the charges against him, and we'll be back in the courtroom on Thursday for further arraignment?
Yes, and that's all that happened. It's just to continue on. We'll give his attorney an opportunity to start looking at the reports. Quite frankly, those reports are not in final form. Our arson investigators in Butte County have been extraordinarily busy over the last 2-3 months for whatever reason. This has been arson season, and they have been very busy investigating cases, determining whether they're arson, and arresting arsonists.
So just to confirm, the charges were not read in court today, however, he was charged today.
Yes, you will.
Okay,
Yeah.
and he did not offer a plea verbally in court today, however, he has pled?
No, he has not.
He has not pled.
No. The continuance of the arraignment will continue to the next, I would expect, on that date, on Thursday. There won't be much going on other than this continuance, so his attorney, the public defender, can take a look and talk to him some more and make a decision as to what plea they want to enter.
So what exactly happens on Thursday that's different?
Then today,
Yeah.
that they will ask him, do you wish to enter a plea today?
Okay, but he may still postpone that again, is what you're saying?
Exactly.
And looking forward, any timeline of how this plays out?
No.
Okay.
That's. I would love to say we're going to be finished here in about 5 days, maybe 5 months. We'll see.
So at the moment, all we know is Thursday.
Yes,
Thank you.
The public defender, what's her first name?
it's Nicole.
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 And it's Diamond?
Yes.
And so I heard you say you've been DA here for 36 and a half years?
Yes.
Okay. Have you had a case like this before? Similar to this?
Yes, called PG&E, People versus PG&E.
They weren't driving a car.
No, they were not driving a car. But we've had cases in which cars have started fires and being stupid, being, as our sheriff likes to say, being that idiot, getting a hot car over into high grass. And that's just, that will land you in jail.
Any overarching statement you want to make on a case like this that we're seeing? Obviously, this is a pretty crazy fire we're dealing with, and obviously, we have a suspected arson. Any kind of overarching statement you want to make as the DA about this case?
It's just, this didn't have to happen. That he was pulling off the side of the road, went over the berm. There's indications he was highly intoxicated at the time. And then into the grass, then trying to get out of the grass by making a concerted effort to rev the engine and get out, causing a fire that has grown to be this monster.
Before we wrap up, may you please just say your full name, spelling, and title?
Full name's Mike Ramsey, R-A-M. This is,
You prefer Mike instead of Michael?
I prefer, yeah, because Michael reminds me of mine. I was in trouble.
Just one more question. You mentioned earlier, when we were asking kind of what do you think he was thinking, you said, why wonder what a crazy mind was thinking or something along that line. Do you think he was in a sound mind when he did this? You mentioned something about intoxication.
And as a note in this area, voluntary intoxication is not a defense to arson.
Okay.
Was drugs or alcohol found in the system?
Alcohol was found in the system.
Was it above the legal limit?
Yes.
Are you able to say what that was?
Well, understand that he was not arrested at the scene. He was, witnesses have indicated that they had seen him at what they call bear hole, which is up the creek. That at that particular location they noted that he was drinking and seemed to be highly intoxicated. Another witness saw him driving down from Bear Hole down towards where he ended up at the alligator hole, and was driving extraordinarily recklessly and speedy as a rough gravel road, and appeared he was driving between 30 and 50 miles an hour. And so that's where we're at there.
J. Ramsey, did he get out of jail early, or did he serve his full sentence for those prior crimes?
He served his full sentence according to the Department of Corrections. That means 20 years in any time. You say so many years, the Department of Corrections makes the final determination, and usually it's 2/3 of a serious crime.
Was he alone? When you did all this, was he
Yes,
alone?
he was.
So we have witnesses who saw him drinking beforehand, and then when he was arrested, there was alcohol in his system the next morning.
The next morning, when he was arrested around 1:30 that morning, when he was finally booked into the jail, and that was some hours later, he was still above the legal limit. But now, don't want to be misleading. He had gone home, and the arson investigators, my investigators, were searching for him and getting an arrest warrant for him, and surrounded his particular trailer and asked him to, and his mother and another party to come out with their hands up, and they did.
Was that his mom in court today? Who yelled
I
at him?
have no idea.
Did he make any statements when he was arrested?
Yes.
Are you sure that was?
No. Other than just generally to let you know, so out of fairness to the man, that he's admitting up to a point, and is saying he did not push his car down that hill.
So just to clarify, charges were filed, but
Yes.
arraignment
You
was
have
delayed.
those charges.
Yes, okay, and they were filed.
Yes.
Right,
That's where the file stamp at the top shows.
right, okay.
I know you obviously stated this in court, but if you wouldn't mind for the cameras, explaining why you ended up pursuing no bail for today.
No bail today because of his record. The fact that he is facing life imprisonment. That this was an extraordinarily dangerous act. And he does appear to have an alcohol problem. And so we can't have such a dangerous person out there in the community, particularly in these times that we're under, as has been indicated, this fire was started in the area. It went north from that area. It's one of the few places in the Northern California that's had fires, huge fires burning all around that hadn't been burned, no record of being burned. It was like all of the brush and the trees were dried in a kiln for the last 2 weeks, and temperatures well over 100 for some 2 weeks.
Dear Ramsey, does Sheriff Coney have him under suicide watch or any special conditions in jail because of the seriousness of this crime?
Does he? And I missed the very first part.
So does Sheriff Coney have him under suicide watch or making sure that there's no other
indication of
issues?
suicide watch,
Okay,
no.
thank you.
Okay. Anything else? There's alligator for you folks. And that is this is Big Chico Creek. Comes along here. This is the parking area. The hole is down here. He went off of the road right here. And there's 370,000 acre fire. Straight right there. Now, what I'm doing. Okay, this is drone footage where the fire started. And the car is right here. Park here in the shadow of this tree, and car rolled down to that area. See this be any of the shots that you have, do have, get to it again. Here's your V. Let's start. This is some 40 miles long, some 15 to 20 miles wide. And there's the car. A 2007 Yaris.
Yaris.
And to answer the question that I've received many times, this is kind of a hatchback. There's no dead bodies in the back. All right. So, I mean, I got that call several times. Did you check the trunk? Did you check the trunk? No, it doesn't have a trunk. It's a hatchback. No blowing out. It's nothing would indicate the motive is to get rid of something. Alrighty?